So I just want to open this event by thanking Russell and Krisztian for their availability to come virtually overseas here and talk with us, bring their thoughts about vertical integration and vertical restraints. This is certainly a hot topic here in Brazil as well. We are currently discussing our guidelines, and there is a group formed by CADI in which IBRAC is also participating. I'm sure Ana, Vivian, Bruno, and Adriana will talk about that. So thanks for joining us. Thanks for being here. Thanks for being partners of IBRAC for all these years. And hopefully we can continue to have your cooperation, have your bright thoughts about what is going on in the US, bringing your experience here to us for the next years as well. Thanks a lot. I'll pass the word to Ana, perhaps, or Adriana. I'm not sure.
Yes. Thank you, Bruno, for the introduction. So I also want to thank Russell and Krisztian about getting together with us. It's a pleasure, and we are happy to learn more about the American experience today. So just before going to our conversation, I would just want to talk briefly about our working group on the unilateral conduct, and then Adriana will talk about the vertical integration group as well. So since 2019, our working group has been doing some work on analyzing benchmarks and also the Brazilian jurisdiction. And this year we are focused on the analysis of standard of analysis and the design of remedies. So we have been reviewing a number of cases for each type of conduct, and we are willing to understand if the Brazilian authority has any threshold that it would be interesting to analyze for each type of conduct, as well as understanding the mechanism and the way that remedies are designed here in Brazil for unilateral conduct. So some of the topics that we have been discussing in our group, we'll discuss with you today, and we are happy to do it now. So Adriana, before going to the conversation, Adriana would like to talk about the working group on vertical integration.
Yes, thank you, Ana, and thank you for the invitation, Ana, to be part of this discussion. Well, on behalf of IBRAC, I coordinate with Vivian the study group on vertical integration assessment with the goal of providing a framework of analysis for these cases. Our hope was eventually motivating the Brazilian antitrust authority to develop its own guideline. And so we are very fortunate indeed this year because CADI has started its own study group to discuss the framework of analysis, the ultimate goal being the development of the first Brazilian vertical integration guideline. So we joined forces with CADI, as Bruno said, and we are working all very hard. I mean, when I say all, we have dozens of voluntary contributors on the part of IBRAC, which shows how long-awaited these guidelines are here. So our contribution lies in developing knowledge needed to go forward in this important task. We are mapping national and international jurisprudence on vertical integration, understanding the safe harbors that were used, the framework of analysis, the most relevant theories of harm that were considered in the decisions, and finally, looking forward, we are mapping the new trends on vertical integration assessment. So that's why we are very eager to learn with you, and that's why I will pass the word to Bruno, who will introduce our prestigious speakers. Thank you very much for the invitation again to be part of the discussion.
So good morning, everyone. Thanks, Ana and Adriana. And thanks again to our speakers for accepting our invitation. So let me introduce our guests. So Russ is the Associate Director of the Federal Trade Commission's Office of International Affairs. He has been with the FTC since 1985 and has served in various capacities in the bureaus of competition and consumer protection, and as Assistant Regional Director of the FTC Regional Office. He serves as an adjunct professor of law at Georgetown University Law School and is a member of the editorial board of the Antitrust Magazine Online, published by the Antitrust Law section of the American Bar Association. Krisztian is Vice President of Global Competition and Regulatory Policy at the Computer and Communications Industry Association in Washington, D.C. He has more than 17 years of experience, including serving at the FTC as Counsel for International Antitrust and as attorney in the FTC's Technology Enforcement Division. Previously, he worked on antitrust and competition matters in the private sector. Krisztian holds law degrees from Hungary, France, Germany, and the US. Currently, he's also working on his PhD with Bill Kovacic at the George Washington University in Washington, D.C. It's incredible. So, Vivian, the floor is all yours.
Thank you, and thank you so much again, Russell and Krisztian. It's really a pleasure having you both here. I don't know if the young crowd watching us today know about that, but let me register here that Russell is a true living legend in the competition space. And Krisztian, likewise, as you mentioned, Bruno, is one of the most competition law experts globally. And he has been named by the Global Competition Review one of the top 40 competition lawyers under the age of 40 internationally. Together with Adriana, on behalf of IBRAC's Task Force for Vertical Mergers, I also need to thank our members. This is a dedicated group of over 60 brilliant people we are very fortunate to have on board. So for each and every one of you, please receive our appreciation of your hard work, of your valuable contribution in regards to IBRAC Vertical Merger Working Group. So without further ado, I want to start it off by asking Krisztian a question. As we have been seeing that the basis for the enhanced antitrust enforcement on vertical issues at the US Antitrust Division have been discussed a lot, but rarely understood from a non-US perspective. So there are scholars who think Chicago School for the past decades has been lenient, to say the least, towards the enforcement of these vertical restraints. But looking back in retrospect, could you talk about the historical perspective of vertical integration analysis, about guidelines reviews, for instance, ex-post studies and cases that influenced changes in the analytical framework?
Sure, e muito obrigado, Viviane. Bom dia a todos. Primeiro, eu gostaria de agradecer pelo convite ao IBRAC e também pela oportunidade de apresentar aqui esta manhã. É uma pena, né, que esse evento não pode ser presencial hoje, mas é um prazer estar aqui falando com vocês sobre fusões verticais e integração vertical em antitrust. Então, eu acho que vou continuar a minha fala em inglês agora. And turning to the topic of our discussion, Vivian, as you mentioned, kind of like the vertical integration analysis, and this enforcement area has actually had a very interesting history for the last few decades in the United States and globally. And just to briefly provide a glimpse of U.S. antitrust history in this space, before the 1950 Clayton Act amendments, vertical merger cases were tried under the Sherman Act, and very few cases were ever litigated. Then in 1950, Section 7 of the Clayton Act was expanded to vertical mergers. And then the Supreme Court of the U.S. Supreme Court in the 1960s, shifted to stricter vertical merger enforcement in light of those developments. And without much economic reasoning back then, the court really blocked several relatively harmless mergers, including, pro-competitive mergers involving players with small market shares or those involving pro-competitive efficiencies. And I think, Vivian, you also asked about leading cases. And perhaps, the most famous case from this era back then was the Supreme Court's well-known decision in Brown Shoe from 1962. But just to fast forward then, starting in the 1970s, especially based on the new economic learning and of course, scholars associated with the Chicago School, you see that the US Supreme Court really shifted to a consumer welfare standard approach. And it started then considering not just potential anti-competitive effects, but also the benefits of vertical merger efficiencies. And this shift in economic thinking really has also been reflected in core decisions with an emphasis on efficiencies. Since then, of course, the majority of vertical mergers have been generally considered pro-competitive or benign. Now, I just wanted to mention that it's very interesting and important to see actual vertical merger enforcement numbers. And when you look at the US, on average for the last 20 years or so, the US agencies, the FTC and DOJ, closely reviewed on average about 2 or 3 vertical deals per year. And they challenged on average about 1 vertical merger per year. Interestingly, this number is kind of like lower than the general ICN vertical merger survey results from 2018, because the ICN surveys show that internationally, about 1 out of 10 mergers analyzed by antitrust authorities corresponded to vertical mergers. And this number, what we see now over the last years, as you mentioned as well, question, we see that, these numbers in a number of jurisdictions now have slightly been growing in recent years. And that is true, in the US, Brazil, and other countries. Just looking at the Brazilian experience, this vertical merger enforcement by CADE recently included from the last few years, for example, of course, the AT&T Time Warner matter, which was, of course, also reviewed in the US and the number of other jurisdictions. And when I was looking at Brazilian examples, I also saw the proposed merger of, Petrochemex and Petrobras Pernambuco, which was a couple of years ago as well at CADE reviewed. In the US, if you look at the US agency's experience, the FTC had 3 recent vertical merger challenges just over the last about year and a half. Now, I wanted to tie this short historical introduction to the actual merger guidelines and the guidance process. So what we see is over the years in the US agencies, the FTC and DOJ, the agencies issued merger guidelines that outline, of course, their merger analysis. But it's interesting to see that while since the first set of guidelines in 1968, that was the horizontal merger guidelines, have been updated regularly about every 10, 15 years in light of, new experience and economic learning. The first 1968 US vertical guidelines were actually only updated once in 1984. And then again in 2020, there was a set of vertical merger guidelines by the agencies back then, to which exercise I will turn in a bit more detail. But regarding these June 2020 vertical merger guidelines in the US, there have been a number of calls prior to that, since 1984, to actually update the 1984 vertical merger guides. And one important one was in 2007, the Antitrust Modernization Commission's report. And then also the AB antitrust section a number of times has also mentioned that, those guidelines have been outdated for a while. So you mentioned CADE's working group, on updating or creating now the first set of vertical merger guidelines in Brazil. And a few weeks ago, I actually had a opportunity to make a presentation to the working group as well, working with CADE. So also looking at the current Brazilian experience, I think it's very important to just step back and think about, the actual reasons to adopt guidelines. And first, what we see is in the US and internationally is that antitrust agencies may use guidelines to clarify how they intend to approach topics on which perhaps there is no clear binding precedent. But then agencies, may also use guidelines to advance new analytic techniques. And we saw that a couple of times in the US experience in history. For example, the 1982 horizontal merger guides in the US, adopted the hypothetical monopolies test. And then in 2010, the updated US merger guidelines sought to popularize guppies. And I know there are many, economists or the Economic Committee as well, joining today's call. So just to be sure, our understanding of vertical mergers in the US has changed since the 1984 guidelines were issued. And just to wrap this up, but what was actually the reason behind, the 2020 vertical merger guidelines update in the US? And, what we saw is since the 1990s or the last 20, 30 years, there has been a new wave of economic literature that really introduced, models of exclusion, entry deterrence, market foreclosure, and of course, raising rivals' costs that, raised some potential concerns about the proper treatment of vertical mergers. And given that vertical merger competitive effects modeling, I would say, is still more art than science, I'm actually not aware of legal or empirical economic scholarship that would actually merit an across-the-board significant increase in vertical merger enforcement above these current levels. So really the question is, how big of an issue is it in practice? And when it comes to vertical merger enforcement, what is the level of priority agencies should devote to vertical mergers among, many other competing policy goals and objectives? I probably stop with my initial introduction here. Thank you.
That was great, Krisztian. And I believe this one is for Rachel. So Rachel, Krisztian has mentioned about where FTC is today and his perspective also for the near future, but we would like to hear that from you also. And also we would like to understand how is the process of reviewing the guidelines in the FTC. For example, what is the role of the commissioners in this process of reviewing?
Okay. Thank you very much, Anna, and thank you to IBRAC for inviting me to this. IBRAC is just a storied institution, and I think is responsible for a great deal of the success of competition policy in Brazil. Before I go further, I have to start, as I'm required to say that any remarks, my remarks today reflect my own views and don't necessarily reflect the views of the Federal Trade Commission itself or any of its individual commissioners. So as to where the FTC is today, U.S. law has always applied to vertical mergers just as much as to horizontal ones. But for many years, the U.S. agencies were very deferential to vertical mergers. And the thinking was that since they didn't involve producers at the same level of production, these were likely to produce efficiencies and eliminate double marginalization. And so while the legal framework affecting vertical mergers was intact, as Krisztian pointed out, rather few cases were brought. And for those that were challenged, the agencies, FTC and DOJ, were willing to fashion very regulatory behavioral remedies that required prolonged agency oversight to prevent the integrated firm from self-preferencing or refusing to provide key inputs to rivals. Now, one of the great things about the competition field is that we are constantly learning, and our enforcement approach evolves along with that learning. And vertical mergers give us a perfect example of how we're taking what we've learned and how that is changing our enforcement approach. Now, fundamentally, what we've learned about vertical mergers is there's a very real risk of anti-competitive injury where the vertically integrated firm can use its upstream or downstream control to harm the competitive viability of rivals. But that risk is a real one. And we can't dismiss it based on an unfounded theoretical presumption of efficiency or the assumption that any savings that are generated by eliminating double marginalization will be passed on to consumers. And we've come to question our ability to write strong remedies that prevent integrated firms from sharing information about their rivals within the company or acting in other ways to disadvantage unintegrated rivals. And in fact, we have learned otherwise. I'll give you an example of mergers between hospitals and physician groups. That's a classic vertical transaction, and it's led to significant concentration in many parts of our country. But they don't appear to have achieved the theorized efficiencies. Instead, we've seen increased physician costs, hospital prices, and medical spending, especially in these concentrated markets. Likewise, several years ago, when AT&T acquired DirecTV, the parties argued that the merger would lead to downward pricing pressure. But after the merger, it began raising prices. And in another vertical deal that Krisztian mentioned, AT&T fought very hard to buy Time Warner, fending off a strong DOJ challenge, only to turn around 3 years later and sell it off. So as a result, FTC as well as the Department of Justice are increasingly skeptical about the benefits of vertical integration in already concentrated markets. And we have renewed humility about our ability to fix them through the remedial process. So turning to your question about the review process, the agencies are working now to review new merger guidelines, and those are likely to provide new guidance on how we're going to address vertical mergers. Now, it's worth pointing out that guidelines do not themselves make law. Our law is found in our statutes, which prohibit mergers whose effect may be to substantially lessen competition or tend to create a monopoly, as well as unfair methods of competition, together with judicial decisions that authoritatively construe what those terms mean. Guidelines are simply intended to provide transparency into the standards the agency apply in reviewing mergers. And the objective is to ensure that our merger guidelines correctly reflect modern market realities and equip us to forcefully enforce the law against unlawful deals. Now, as part of a broader initiative to democratize the work of the agency, the guidelines process is being informed by an unprecedented degree of public participation and input. In addition to the public comment period we always have, which was open for over a month, we got an unprecedented 5,825 comments. And we also held listening sessions to hear from those who've experienced firsthand the effects of mergers and investigations. We went beyond antitrust experts, brilliant as they all are, and included consumers, workers, entrepreneurs, startups, farmers, investors, and independent businesses. Right now, the FTC, along with DOJ, is carefully reviewing all that we've been learned, and we're consulting with each other to prepare draft guidelines. And once they are promulgated, they'll be posted for public comment before they are adopted.
Thank you, Russ. Very, very interesting indeed. So could you also tell us about the main changes that have been discussed on these matters? For instance, are there new theories of harm, or are they going to be included in the guidelines? Issues related to efficiency gains, weeding out anti-competitive effects as well. And beyond the discussion of the vertical integration, could you also give us your thoughts on how this discussion would affect antitrust enforcement, both in the US and other jurisdictions? And Krisztian, we would also like to hear your thoughts on that too. Thanks.
Okay. Well, I'll start off on this. I can't tell you what the guidelines will look like because we're still in the process of creating them. But I can talk about some recent merger challenges that I think reflect directionally where we're headed in some aspects of the guidelines. So looking at non-horizontal mergers, the existing legal framework that applies to vertical mergers came to the US Supreme Court case that Krisztian mentioned. It was from the early 1960s, known as Brown Shoe. The case involved a merger between a shoe manufacturer and a major shoe manufacturing chain, and that raised concerns about whether Brown Shoe's control of the retail chain would impair the ability of other manufacturers to find outlets and compare and sell their shoes. Now, while that kind of foreclosure isn't the only type of harm that can result from a vertical merger, in cases of foreclosure, the courts have looked to evidence of the degree of market foreclosure, the nature and economic purpose of the merger, the concentration of sellers and buyers, any trend towards vertical concentration, any increased barriers to entry, and harm to small businesses. So when I say that the merger guidelines by their nature reflects what the settled law is, I think it's worth looking back and saying this is what the law is on vertical integration. So in the meantime, we have been acting resolutely faced with concerns about the anti-competitive impact of vertical transactions and underscoring the skepticism of remedies for those transactions, since structural remedies are rarely available. So let me give you some examples. In February, the FTC filed suit to block the merger between Lockheed and Aerojet. That was a defense merger, which would have eliminated the country's last independent supplier of key missile propulsion inputs and given Lockheed the ability to cut off its competitors' access to these inputs. Now, Lockheed is the world's largest defense contractor, and it's a leading missile supplier in a very concentrated sector. And now Lockheed is one of 4 competitors for the missile market. Those 4 competitors act as missile system private contractors for our Defense Department. And they're key intermediaries between the government and the rest of the missile supply chain, including subcontractors such as Aerojet, which provides system components to them. Aerojet, for its part, is the last independent U.S. supplier of critical inputs for missile systems, hypersonic cruise missiles, and missile defense kill vehicles. I have to say these are difficult markets to talk about, but the recent events in Ukraine have reminded us why the world does need to have these kinds of products. Now, in the propulsion input market for missile systems and hypersonic cruise missiles, Aerojet had only one other competitor, and Aerojet's the only proven supplier of a certain type of system that propel these kill vehicles. So the bottom line is that Lockheed's proposed acquisition would have given Lockheed control of these critical propulsion inputs that its rivals would require to compete against Lockheed. So the deal on the bottom line would have resulted in higher prices and, maybe more importantly, diminished quality and innovation for programs that are critical to national security. When the FTC sued to block the deal, the parties abandoned the transaction. Another recent case, the FTC went to court to block a chip supplier called NVIDIA to prevent them from acquiring a chip design provider called ARM. The merger would have given one of the largest chip companies control over rivals' design for competing chips. Now, what the FTC said was that NVIDIA was one of the largest computing companies. It develops and markets computer chips and devices, and it's best known for a dominant supplier of something called standalone graphics processing units, or GPUs for personal computers and data centers. And they're used widely for artificial intelligence processing and graphics processing. NVIDIA also develops and markets products for advanced networking, data center, central processing units, and computer-assisted driving. When I started out in 1985, none of these markets even existed, so it's a steep learning curve. Now, ARM doesn't supply or market finished computer chips or devices, but instead creates or licenses microprocessor designs and architectures to other technology companies, including NVIDIA. Now, those companies, in turn, rely on ARM's technology to make computer chips that run a number of modern computing devices. And NVIDIA and its major competitors rely on ARM's technology to develop their own competing products. Now, the FTC alleged that the combined firm would have the means and the incentive to stifle next-generation technologies, including those to run data centers and driver-assisted systems in cars. The parties also abandoned that transaction after the FTC announced its intentions. We have two other cases in litigation about which I can't say much. Last year, the FTC challenged Illumina's acquisition of Grail, another vertical challenge that involved potential competition. And this last month, the FTC filed to prevent Meta, formerly known as Facebook, from acquiring Within United and its popular virtual reality fitness app, Supernatural, which we alleged would eliminate the prospect of its own entry into the market, which would dampen future innovation and competitive rivalry. So taken as a whole, those cases, I think, say the FTC is not afraid to challenge non-horizontal deals as well as, of course, horizontal challenges. To date, in 22, we've challenged 13 total mergers. Let me go on to your question about efficiency gains. And I think that's a really good and interesting question. Our statute doesn't say anything about efficiencies. Even under the existing guidelines, which was more of a statement of agency intent as to what they will consider, the efficiency gains were never allowed to outweigh competitive effects. It said that if the effect of the merger may be to substantially lessen competition, the agencies would block it. Efficiencies could be evaluated to assess whether the overall effect of the transaction might be anti-competitive, but it would never justify an otherwise anti-competitive transaction. That's a subtle but significant difference. I can't tell you whether or how the new guidelines will address efficiencies, but the FTC's experience with them have created great skepticism about whether giving too much weight to efficiencies may have led the agencies to give too much deference to deals that prove to be anti-competitive. Industries have become more concentrated and less competitive. So I think it's a safe bet that the focus of the guidelines will be on whether the deal will substantially lessen competition.
Bruno, did you ask for my thoughts on some of these points as well? I recall. Okay, yeah. Perhaps, like I would highlight when it comes kind of like the potential impact you asked about regarding kind of like enforcement in the US and its impact, broader internationally as well. And I think, also following up on what Russ said, like focusing really on the ongoing guidelines experience and like also highlighting the importance of regular updates, that I previously talked about. I would just start with noting that the practical significance really of any particular agency guidance really depends on, like on the guidelines reflecting market dynamics and current market realities. And I think it's really important to underscore that, like guidelines, assumptions, and theories of harm, if they are far removed from real world market conditions, the results would be misleading. And in that regard, I just want to also highlight they could actually harm competition and innovation in the marketplace. So this is something that agencies, as CAG is also working on its first set of vertical merger guidelines, really should kind of like constantly remind themselves about. But then looking at the guidelines exercise, I think it's very important that those reflect, in addition to market realities and agency experience, they also try not to create potentially new and untested theories for merger enforcement. And again, in that regard, any change in the merger law really should come from Congress and the courts, not necessarily through guidelines. But in that regard, thinking about kind of like guidelines by agencies, like my general concern can be that, at least in the US, earlier this year, for example, their agencies' requests for information that Russ also mentioned, we had over 5,000 or so comments, and I also submitted, like comments in response to that exercise, reflected potentially a number of presumptions. And what we see is that, in the vertical area, for example, it seems that there is simply not enough evidence to indicate that these presumptions effectively avoid potentially eliminating beneficial mergers. So there's always the question of, like what are kind of like the, part and part two errors, which side, like would an agency want to err on? But I think because of this, it's very important that more agency experience, ex post studies of vertical mergers and litigation experience of vertical mergers and also strong empirical evidence is really needed to support kind of like any proposed presumptions. one aspect of this is kind of like the relationship between, vertical merger enforcement and entrepreneurial exit in the market. And for example, in the US, Professor Danny Sokol from USC actually had a couple of excellent articles describing this phenomenon. And the broader implications there are that, like when it comes to vertical mergers and presumptions of legality, there's this overlooked implication, which is that a change in policy and potentially, overly strict vertical merger enforcement could actually dampen entrepreneurial investment and innovation in the market. And in that regard, entrepreneurial exit, it's very important, is really critical to a well-functioning innovation ecosystem, as the possibility of entrepreneurial exit is now simply the most common form of liquidity, even for founders and venture capitalists. What does that mean in practice? It actually means that many startups, entrepreneurs in numerous industries, and that includes, finance, pharmaceuticals, medical devices, technology, hardware, and also in other connected sectors, you see that entrepreneurs and venture capitalists invest to actually be bought out, to be acquired. And this also came up, in an OECD roundtable in 2019 that I participated in on vertical mergers in media and technology markets. It seems that making it more difficult than necessary with an overly restrictive merger control regime could actually significantly harm innovation in the broader economy. And this is something that I think agencies really should keep in mind as they're looking into creating or updating guidelines. And just the last point, like what kind of impact it may have on other jurisdictions, you asked. We all know that agencies work very closely together bilaterally and in multilateral fora. I worked on those issues, for 15 years at the FTC, and Russ has been, I worked closely with Russ and others in the FTC and other agencies on international cooperation. But that means that potentially proposals, that could even be, harmful, or so could actually impact other jurisdictions. So I think it is really common to see that agencies around the world sometimes rely on international antitrust experiments. And there are a lot of merger regimes that are actually functioning really well, and they're effectively reviewing and preventing anti-competitive acquisitions. So I think agencies really should keep this international perspective in mind as they're adopting new guidelines or updating new proposals. But that, like when it comes to potentially leading to an overly restrictive merger and control, it may and actually will have a significant impact, not only on the national economy and innovation ecosystem, but it could have implications in other countries as well. Back to you, Bruno.
So this is a very interesting point, because we have to, as Russell said, there are sectors that they're so new, and we have to understand, and now we also have to discuss potential innovation, potential competition, and how do we put that in a guideline in a way that you don't err too much. So, CADE has initiated this workforce to develop guidelines for vertical integration. So what are the main suggestions for developing countries like Brazil to better channel its efforts towards strengthening our market economy or market competition? So I'd like to listen from Krisztian and also from Russell regarding this topic. How do we adjust? How do we design a guideline that is appropriate to our institutions?
Sure, I'm happy to respond. And I think it's a really excellent question to provide a perspective of kind of like, the broader kind of like market and what role competition and of course, guidelines play in that regard in different jurisdictions. First of all, as I previously mentioned about the guidelines exercise, I think it's first and foremost very important for an agency, including CAGI, to really regularly review its tools and provide additional guidance in specific areas as needed. And again, in this regard, I would like to congratulate, like Alexandre, Ana Sofia, and of course, members of the CAGI working group on taking this initiative and moving it forward. In addition to being in touch with them, I think it's very important to see that they're also looking at international experience and examples and what potential lessons learned or kind of like learning could be useful in that regard. But I would also, on the same kind of like note, would like to commend IBRAC on participating in this effort, because it's very important that, you engage as a private sector, legal and economic perspective. You provide that as the agency is looking into kind of like creating these guidelines, and there's a constant, engagement between the public and the private sector. But regarding the experience of Brazil compared with other countries over the years, and I think you asked him specifically about developing countries in particular, and I think one common theme that we see is, that some of these economies must deal perhaps more frequently with more concentrated market structures. And I think in that regard, some of the concerns I just previously expressed regarding entrepreneurial exits and innovation ecosystems might be exacerbated because of that. And why is that? It's simply because the startup and innovation ecosystem in developing jurisdictions perhaps might be more fragile or simply less robust. So anything, guidelines or so might have an even bigger impact in that regard on the market economy. I'd also like to refer, to actually CAGI's submission on vertical mergers in technology and media to the OECD Roundtable in 2019 that I previously mentioned. I spent a few months working at CAGI as an FTC resident advisor back then in 2019. And I was looking at, that paper that, it actually highlights that one important challenge for the agency regarding vertical merger enforcement is really that you touched upon in one of your previous questions, which is the speed with which technology markets change. And then in that regard, the markets in which these mergers often take place that the agencies are looking at. So because of that, the agency, as CAGI also mentioned in its statement to the OECD, the agency has to constantly review its position due to these rapid changes in the spirit of promoting competition and innovation in the marketplace. And I think another important challenge that was noted in that particular paper was that we also should think about kind of like the non-price effects that have to be considered in vertical mergers, in particularly, in these fast-changing industries. And I think the intensity of innovation makes the future in that regard even more difficult to predict. And as CAGI also noted, the authority has to be extra careful in its analysis to make sure that it really continues to promote competition and innovation in the marketplace. Then let me mention one other specific Brazilian example here, which I think was really interesting that I personally experienced. 10 years ago, as the 2011 Brazilian competition law went into effect in 2012, it introduced, as we all know, pre-merger notification system. And I recall that back then, gun jumping issues, were really a key concern for the private bar. I think I personally back then gave 2 or 3 speeches to CAGI and at the annual IBRAC as well about the U.S. experience in gun jumping. And I recall actually Ross and I doing a program together on this issue back then. But in any event, CAGI then later released gun jumping guidelines a few years later. I think it was in 2016, which were then amended further, I believe, in 2019. However, having followed, gun jumping developments in Brazil ever since, I think over the last 10 years, CAGI had penalties in slightly over kind of like a couple of dozen cases. I think earlier this year that was this additional Veolia Suez case. But we see that this gun jumping Armageddon that many competition practitioners had been concerned about actually didn't materialize with the introduction of a pre-merger regime. Fortunately, it's CAGI prepared guides to actually provide predictability and consistency on how it looks at these issues. But the simple fact that the agency puts out guidelines, it shouldn't be the basis of automatically increased scrutiny or necessarily introducing new or untested concepts of theories of harm in that regard. And I think that the same concept is true for the vertical merger guidelines, which really should reflect market realities and current economic thinking in every jurisdiction. And my very last point in that regard is, I think it's very important what I would also just call Brazil's special responsibility in Latin America. And I think in that regard, I mentioned, working at CAGI, for example, a few years ago and working closely with agencies in the region, you see that CAGI is working very closely, of course, with other Latin American and international competition authorities. And I think in that regard, Brazil, as the largest economy in Latin America, really serves as an example for other countries in the region and globally as well through other fora, whether it's BRICS, whether it's other international fora. And we see that in the merger control area as well. For example, both CAGI and the FTC provided technical assistance to Peru and its agency, Indacopi, as it introduced merger control just a couple of years ago. And of course, CAGI has reviewed a number of vertical merger cases over the years, including what we talked about, Time Warner, AT&T, Petrotemex, Petrobras, Pernambuco, and others. So I think with robust merger enforcement and policy, really CAGI has been a model agency in the region. And we see that in international organizations as well. For example, with Brazil becoming, an associate member of the OECD Competition Committee in 2019. So I think CAGI in that regard has been particularly active on the international antitrust landscape. So as one additional suggestion, I think it's just important to keep in mind that, the agency and CAGI really has been doing a great job in that regard. It should continue this strong and active international engagement and cooperation and collaboration with other agencies in the region and beyond.
Okay. First of all, from the FTC's point of view, we wouldn't presume to make suggestions to CAGI about how to analyze vertical mergers. It has great people and great analytical ability, and they can bring those capabilities to work to support its mission to protect Brazilian citizens. But kind of reflecting what Krisztian said, the world's competition agencies we're collectively stronger when we can work together and apply strong and consistent standards to ensure that anti-competitive vertical mergers, like any other type of conduct, doesn't result in the loss of competition that's important to both national and global markets. I will say a couple of things in response to Krisztian's excellent remarks, and he raised some extremely important issues, one of which was on structural presumptions. So the problem with bringing a vertical merger case or almost any other kind of case is that if you certainly need the evidence, but if you're starting from scratch, you typically have to go out and get a Nobel Prize winning economist on your side, and then the other side goes out and needs to hire another one. And that can get very expensive very quickly, and it makes it very hard to bring as many cases. So the question with a presumption is, are there some presumptions which are reflective of economic reality, which can shortcut some of the cost of enforcement for both sides? I also agree that we certainly don't want to dampen entrepreneurial innovation, but at the same time, we need to stand back and take a look at how the policies have played out and ask, are we comfortable with the degree of consolidation and concentration which we have had under the existing differential policies? In other words, do the results in some way speak for themselves? Entrepreneurial exit is also an excellent point, and it's true that many startups' dream is to sell out to Microsoft or Amazon and then to enjoy the fruits of the innovation. But at the same time, we have seen a pattern of repeat acquisitions of small startups that have had the effect of making sure that no one is ever able to grow large enough to challenge some of these firms. So those are all things that we're paying attention to in this effort and trying really hard to get the balance right.
Thank you. So moving on, we are running out of time, and we would like to hear also your thoughts on remedies related to unilateral conduct. So we know that in the unilateral conduct, you have a fact already, so you don't have to make assumptions about the future. You already have a past that you have to investigate all about it. But you may also have it's a challengeful investigation. You have to see what was a cause of an anti-competitive practice, or it wasn't. What the effect on the economy, you have to deal with that difference. So there are advocates that for the structural remedies that thinks this will be a good way to prevent anti-competitive practice. So want to hear your thoughts on that, especially in which situations this seems to be appropriate, what are the risks behind this proposal, and if it would be more helpful if we will make a redesign of the behavioral remedies. We think about which behavioral remedies are more effective and which are not. So.
Okay, now that's a good and a very important question, and one that we're thinking a lot about, which is you can run the best investigation of a merger or a conduct in the world, but then you, at the end of the day, you have to say, what are we going to do about it? What kind of remedy will improve the situation? And there's similar considerations for vertical mergers as with unilateral conduct. The FTC has a strong preference for structural remedies such as divestitures, but that's often not something which is available in a vertical merger or in the case of unilateral conduct. If you have a single entity, you just might not have anything that you could effectively spin off. So those are unlikely to be available in vertical cases. So going forward, building on the lessons of the last decades, the FTC is not likely to accept behavioral commitments from parties which are looking for an easy fix. The problem with behavioral remedies is they are very hard to police. It requires a lot of resources to go and look into exactly the details of business conduct, which really isn't what the government should be doing. They're very easy to circumvent. They often provide a roadmap for how to get around them. And our experience has been that they're really unlikely to prevent anti-competitive harm. So I think in the US, you're going to see much less reliance on behavioral remedies than was the case in the past. And if you don't have a fix, you shouldn't be accepting a consent.
Thank you so much. I would like to open the floor for any questions from the audience. Please feel free here to put your questions here in the Q&A button or raise your hand.
Vivian, I have one.
Okay.
So I hear that the U.S. agency's new draft merger guidelines will likely be a joint set, covering both horizontal and vertical issues. So Krisztian or Russ, any views about this particular format of having a joint set of guidelines? Krisztian, perhaps you can comment on that.
Sure, I would also love to hear from Russ on that, because this actually, has been, when it comes to kind of like the, I previously talked about the request for information from earlier this year that, took place, I think, in between January and April in the US, potentially it already kind of like flagged some presumptions in that regard that there might be, I think there's no kind of like public statement about it, and Russ can correct me, but there's a general sense, at least in the antitrust board, that they're likely, or there could be kind of like a joint set of, like horizontal and vertical merger guides together. I think in that regard, what's really important is that, all possible theories under which mergers can harm competition and really thereby violate Section 7 in the US, are either horizontal, vertical, or conglomerate. And these theories are really categorized by the mechanisms of harm. I think, what we talked about in detail, both Russ and I, is, the main objective of agency guidelines is really to promote, transparent and predictable merger enforcement. So the question whether, in that regard, I think the question whether a proposed combination is vertical integration versus a horizontal one, it really remains very important and relevant in merger analysis, in addition to the fact that it might be often, as we see, within the same case that might have both, horizontal and vertical implications. So I think in that regard, at least from an industry perspective, just kind of like my addition to that is, I think it would be helpful for companies and also to courts alike to kind of like maintain a distinction between horizontal and vertical merger guidelines, but it's more kind of like what obviously they substantively say than whether it's, one document or kind of like different sets of of documents. And I would also love to hear from Russ about it if he has anything to say. So it's a great question, Bruno.
I don't have much to say, but we have the unique situation in the U.S. where we have the two competition agencies, and we've long recognized that we need to work together to come up with a consistent enforcement message, and I don't see anything different happening this time.
Thank you.
Thank you, Russell. I know that you have to leave, so I want to thank you for being here, and also to Krisztian. And you guys have certainly shed light on the U.S. perspective on vertical mergers and vertical integrations. As the very distinguished law professor William Baxter once said, that writing guidelines is hard work. Well, tough to disagree. But CADE can rest assured that our working groups will put their best efforts together to assist CADE in this important mission, so all to aim at greater predictability and greater transparency for the business community. And the private bar and enforcers will make this happen. On behalf of IBRAC, I want to thank everyone for watching.